I don't need the lights off just yet. I gotta get the light set up. Thanks. So one of the first things that opposing counsel said in their closing argument was that you should use your common sense. And the state wholeheartedly agrees with that. Use your common sense. We don't ask anybody to check their common sense at the door. The facts in this case, if you look at it using your common sense, you'll see that this defendant wasn't acting like a reasonably prudent person. Now, opposing counsel stated correctly, the state has a high burden in this case. We have a burden of proving this case beyond a reasonable doubt. And that's our burden in every criminal case. Same as a murder case versus a driver's license case, it's the same burden. When we were in jury selection, we obviously hadn't met that burden. The question was asked, I believe somebody, if you had to give a verdict right now, what would it be? Obviously, you heard no evidence, be not guilty. Opening statements. Opening statements aren't evidence. So anything you heard after opening statement, if you had to give a verdict at that point and deliberate, it should be not guilty. But as evidence comes out in this case, that cloak of innocence is stripped away and has been stripped away from this defendant in this case. And with the evidence that's here and the evidence that you heard on that stand, he now sits before you a proven guilty man. So, we do have to meet the elements in this case. And opposing counsel talked about a peanut butter and jelly sandwich, right? So, have a peanut butter and jelly sandwich, you got to have the bread, you got to have the peanut butter, and you got to have the jelly. Those are the three elements. So, a pretty good analogy to the elements in this case. For manslaughter, there's just, the two elements that we talked about, then the three elements for second-degree murder. And that's what we've got to prove. We've got to prove each of those elements beyond a reasonable doubt. But opposing counsel also said in his argument that if you have any questions or any questions about any of the facts in the case, then that's a reason to find the defendant not guilty. That's not true. That's not correct. We have to prove the elements beyond a reasonable doubt. But if you're going back there and you're wondering, well, I have a question whether the victim's car was gray or black. I don't think the state established that. Well, that's not an element. We don't have to prove that. So if you have a question of whether the car was gray or black or something like that that's not an element, that shouldn't influence your verdict. We have to prove the elements beyond a reasonable doubt, and we've done that here. We've made the peanut butter and jelly sandwich, as opposing counsel talked about, because we've hit those three elements for second-degree murder. Opposing counsel talked about a text message that you didn't see the actual text message that Tara Walker talked about. Okay, I mean, you can believe what you want. Obviously, weigh the credibility of the evidence, but she showed up there. You can use your inference, as opposing counsel said. Why was she there? Right? She said it was because she got a text message. All right, you can decide if that makes sense. Opposing counsel talked a lot about the crime scene being contaminated, but how? You didn't hear anything in the testimony, the evidence of how it was actually contaminated. They infer that somehow maybe, with no evidence, that a gun was present and was taken. But there was nothing that you heard. Nobody testified to that. None of the evidence you heard showed that. They talked about, Corporal Morris, the first person that arrived on scene. Yeah, he didn't search the vehicle because the first response was to try to save a life because of the actions of this defendant. And his priority at that moment wasn't to secure the vehicle that he was, right next to. And you can see, that he was there the entire time, that the defendant's father was there, that Tara Walker was there. And she was, by the way, hysterical this entire time. From the moment that this defendant shot the victim in this case, and she runs to the neighbor's house to when law enforcement responds, and you can see on Corporal Morris's body cam, she is hysterical. Is this a person that's in that moment just beside herself? She's gonna take a gun or something and try to hide it somewhere? Ladies and gentlemen, in your instruction, it talks about beyond a reasonable doubt, but it also talks about what's not beyond a reasonable doubt. It's not a possible doubt, imaginary of what could have happened with this gun that was never there, speculative, forced doubt. That's what that is. It's imaginary. It's speculative. Now, opposing counsel talked about the height difference between the defendant and the victim, and yes, the victim was tall. He was 6'8". But this, and you can consider the relative height, but this wasn't a fist fight. This wasn't even something at the time that the shooting happened where they were in arm's reach of each other. It doesn't matter how tall you are when the other person has a gun. And yeah, if the victim and him were engaged in a fist fight, maybe he feels the need to bring a gun out to defend himself at that point. That's not what happened. That's not the facts of this case. So the fact that he's 6'8" doesn't have any bearing on whether his actions were reasonable. They weren't reasonable. Also, opposing counsel talked about, Adrien Payne should have left. Maybe he should have. None of us were there, but there's one person on trial today, and that is this defendant, not Adrien Payne. He's not here today because the defendant acted in the action that he did, and he killed him. That's why. Now, opposing counsel talked about the defendant's son and father being present, but the defendant even acknowledged in his own testimony, begrudgingly, that there were no threats made to his son, there were no threats made to his father. He wasn't protecting them from some sort of threat from the victim in this case. This is a point that I really wanted to address from opposing counsel's argument. He talks about, if you go back and you listen to the body cam from Corporal Morris, you'll hear Terrell Walker say, "Why am I here?" It's not like, why am I here? Like this, and like that's some big conspiracy. I encourage you to listen to that body camera. She is hysterical, and she's standing there, and she's asking, "Why am I here as I watch the father of my child be murdered? Why am I here for that? Why am I living through that?" And there's one reason that she was the defendant. Now, there's a lot talked about by opposing counsel about the knife, the kitchen knife that was found in the passenger seat of the vehicle. And why that wasn't collected. Well, this wasn't alleged to be a stabbing case. There was no allegation that anyone was stabbed or that the knife was used. Also, the defendant, in his testimony yesterday, got on the stand and said he saw this silver object. But when I asked him, "Did you say that in your interview with law enforcement?" "Well, I don't know. It'd been a while." This is right after it happened. He didn't say it then, but he said it yesterday. Why? Because he got to hear all the evidence in the case, and he got to craft his testimony in a way to try to make it seem justifiable what he did. But even by his own words, he couldn't quite wrap it around the requirements of the law. Because even by his own words, what he did was not justified. Now, opposing counsel is right that when he first had his words, or whatever the case was with the victim in this case, and he went in his house, he was not required to call 911. That's true. He's not required to do that. He's not required to cower or anything like that. But that doesn't mean that because he's not required to do that, that somehow that makes his actions justified. He has to meet the requirements of the law that we talked about previously, that his actions were something that a reasonably prudent person would do. Just because he didn't have to call 911 doesn't mean his actions of arming himself with a gun, coming out and shooting a person that's not in arm's reach of him, not on his property, not armed. is reasonable. So yeah, he didn't have to call the police, but he was not justified in doing what he did. So, opposing counsel talks about defending the castle, defending his home. Again, I want to emphasize to you that the victim in this case never set foot at his house, never knocked on his door, never stepped in his driveway, didn't park in his driveway, didn't park in front of his house, didn't step on his grass. He wasn't defending his castle. He saw a vehicle that he recognized. He went over there at 1:30 a.m., had the person roll the window down, and that's what started the engagement between the two. He did that. He's not defending his castle. And then he went back in, armed himself, and came back and shot the person in his car on the street. So, he's guilty. Now, I'm going to play for you the clip that shows the audio and then Tara Walker running afterwards. And you can hear for yourself. You can't see it, but the audio paints a picture. Don't pull your gun out. You were asked to come here. Pleading with you. Do not pull your gun out. Do not pull your gun out. You were asked to come here. Lawrence. Notice what you don't hear there. You don't hear anybody yelling, Adrien, put your gun away. Adrien, don't pull your gun out. Adrien, no. You know why you didn't hear that? Because he was the aggressor. He's the one that pulled his gun out. He was the only person making a threat, and he's the person that's guilty of second-degree murder. The state asks that you find him guilty as charged, and you find all of the firearms enhancements that are on the verdict form that you're going to get. Thank you.
All right, ladies and gentlemen, we'll resume with the remainder of the jury's instructions beginning on page 13, starting with rules for deliberation. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. 1, you must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. 2, this case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits and evidence in these instructions. 3, this case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. 4, remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. 5, your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. 6, whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. 7, your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think that I prefer one verdict over another. You may find the defendant guilty as charged in the information or guilty of such lesser included crime as the evidence may justify, or not guilty. If you return a verdict of guilty, it should be for the highest offense that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. The verdict must be in writing, and for your convenience, the necessary verdict forms have been prepared for you, and I will go over with them with you at this time. The first one is the actual verdict, and then there are 4 special findings that you'll have to make with respect to the firearm. Okay? Each of them has a caption. That's the top portion, and it just indicates that it's the case of the state of Florida versus Lawrence Dority. It has the charge, the division number, which is assigned to this courtroom, and the case number that's assigned to it, and then it indicates that it is in Ninth Circuit here in Orange County. The verdict form gives you 3 options. The first option is we, the jury, find the defendant guilty of second-degree murder as charged in the information. The second option is we, the jury, find the defendant guilty of the lesser included offense of manslaughter. And the third option is we, the jury, find the defendant not guilty. The bottom portion of all the forms is the same. It says, "So say we all," dated at Orlando, Orange County, Florida, on this blank day of July 2025, and there is a place for the foreperson to sign. When you all have reached your verdict, whoever your foreperson is that you've elected needs to do 3 things on the verdict form for me. You need to check one of the 3 options: guilty of second-degree murder, guilty of manslaughter, or not guilty, one of those 3. You need to make sure that you fill in the date, and you need to make sure that you sign the verdict form, okay? You'll need to make sure that you do all 3 of those things, otherwise the verdict form is not complete. If you don't do those things and you come back and I see that the verdict form is not complete, I'm required to send you back in the jury room, and I can't tell you why I'm sending you back in the jury room. So I'm telling you why now, okay? So just make sure we get those 3 things done. In the event that there is a verdict on either second-degree murder or manslaughter, then you have to do the special findings. If you find him not guilty, then you don't need to make any special findings, okay? The special findings, there are 4 of them. The first special finding says that if you find the defendant guilty of second-degree murder, you then must answer this question. We, the jury, find the defendant did, during the commission of the crime, actually possess a firearm. The second option is we, the jury, find that the defendant did not, during the commission of the crime, actually possess a firearm. So special finding number 1 is only required if there's a manslaughter, if there's a second-degree murder verdict from you all, okay? And so then on this special finding, you would do the same thing. You would select either he did possess a firearm or he did not possess a firearm. Make sure the foreperson dates it and signs it, okay? The second special finding also applies only to a verdict for second-degree murder, and it says that if you find the defendant guilty of second-degree murder, you must then answer the following question. And there's 2 options. We, the jury, find the defendant did, during the commission of the crime, discharge a firearm. Second option is we, the jury, find the defendant did not, during the commission of the crime, discharge a firearm. As you did with the other verdict forms, the foreperson will select one of those 2 options, date it, and sign it. And then the third special finding also applies only to the second-degree murder verdict, if there is one. And it says that if you find the defendant guilty of second-degree murder, then you must answer the following question. And again, you have 2 options. We, the jury, find the defendant did, during the commission of the crime, due to the discharge of a firearm, cause death to Adrien Payne. And the second option is we, the jury, find the defendant did not, during the commission of the crime, due to the discharge of a firearm, cause death to Adrien Payne. As you did with the other ones, you would select one of those 2 options, date it, and sign it. And then the last, 4th special finding applies to a verdict of second-degree murder or manslaughter. So if you have any verdict on those 2 charges or those 2 counts, that count or the lesser included, then you would have to do this finding. And it says if you find the defendant guilty of second-degree murder or manslaughter, you must answer the following question. The two options are: we, the jury, find that during the commission of the crime, a firearm was personally carried, displayed, used, threatened to be used, or attempted to be used. Second option is: we, the jury, do not find that during the commission of the crime, a firearm was personally carried, displayed, used, threatened to be used, or attempted to be used. As with all the other forms, the foreperson will select one of those two options, date it, and then sign it. Once you have properly dated and signed and filled out the options for all of the verdict forms that are required, knock on the door, let us know that you've reached a verdict, and we'll bring you in to take it at that time, okay? Now, in just a few minutes, you will be taken to the jury room by the court deputy. The first thing that you all should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your deliberations are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict forms when all of you have agreed on a verdict, and to bring the verdict forms back to the courtroom when you retire or when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberations should stop until the juror returns. You're not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as a blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during deliberations. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the court deputy. Many of you have had cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. The deputies will collect them before you go in. They'll give them back to you when you get out. If you need to communicate with me, send a note through the court deputy. If you have voted, do not disclose the actual vote in the note. If you have a question, I'm going to talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions, if I can, in writing or orally here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. The majority of these exhibits will be sent to you with you into the jury room when you begin to deliberate. The exceptions to that are, obviously, we're not sending a firearm back into the jury room. If you would like to see the firearm, write me a note saying that you'd like to do that. We'll bring you back in and we can show you the firearm, okay? The other exceptions, do you have a device that is approved?
I do.
To go back into the jury room? Have you confirmed it?
I have not,
Assuming the parties are in agreement, then we can send back a computer that doesn't have access to the internet or anything to allow you to do research. It'll simply allow you to play the videos that have been placed into evidence. If that's the case, then I can send those back into the jury room with you. So I just need to know from you all.
Judge, the laptop does need to be plugged in to work. It's an older laptop.
Okay. So it doesn't have a battery either, so you got to old school plug it in the wall. Okay? All right. Any objections?
No objection.
All right. So all the other evidence will go back with you so that you can take your time, use the computer that's provided to review the exhibits that require the use of the computer. The only exception is I'm going to leave the firearm in here. If you want to see it, let me know by sending me a note. Okay? All right, in closing, let me remind you that it is important that you are to follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate the rules that we all share. Any objections to the jury instructions as read by the state?
None from the state, Your Honor.
Defense?
No, Your Honor, thank you.
All right. We had 2 of you that were selected as alternates. So if those 2 of you would remain seated, the remaining 6 of you can go back and deliberate your verdict at this point. And badge number All right, the two of you were our alternates. We select alternates in the event somebody gets sick. Everybody else is healthy, so this will conclude your all's jury service. If you two will just remain seated there, I'll give you some further instructions. The remaining 6 of you at this time may take your notes in the jury instructions and head back to the jury room to deliberate, and they've already gotten their orders. Okay, thank you. All right.
All rise.
Go ahead and hand them these. All right, go ahead and have a seat. All right, gentlemen, you all were selected, as I indicated, as the alternates in the case. Whenever we have a case that's going to go more than a day or two, we will select alternates because life happens, things happen. Had somebody had an illness, a family emergency or something, and they had to be replaced, one of the two of you would have been asked to step in. Fortunately, it looks like the remaining 6 jurors are all healthy, and so they will be doing the deliberations in the case. I know that jury service is an inconvenience. I know that it is an imposition on your time, but it is a very important part of our system of justice and a very important part of American citizenship. And for giving of your time the last 2 or 3 days, I do wish to sincerely thank you. You will not be called for jury service for at least another year, if that's any solace for you. But with that said, this will conclude your jury service. Do either of the two of you need an excuse for the last 3 days? Okay. If you could generate one, I'll have the clerk generate that. You already got it? Yep. All right. So she's already generated it for you. With that said, with my sincere thanks, you are excused from jury service at this time. Okay. Have both the state and defense agreed to all the evidence the deputy's taken back?
State's in agreement.
Okay. All right, go ahead and have a seat. All right, Mr. Dority, you have been present for the entire trial, correct?
Yes, sir.
All right. And you've had an opportunity to provide your input to your attorney at all the important stages and the various stages of this trial? All right. And I know we've talked about them, but we've talked about the witnesses that were called. We talked about the jurors that were picked. We talked about some of the strategy that you and your attorney have made during the course of this proceeding. Have you been satisfied with your attorney's representation of you? All right. Has he done everything that you wanted him to do? Was there anything that he didn't do that you wanted him to do? All right. So is it fair to say at this point that you're completely satisfied with his services? Okay. Anything further from the state at this point?
Nothing further from the state.
Defense? All right. We will be in recess at this point pending a question or a verdict. If you're going to leave, just ask that you give your cell phone number to the trial clerk so that we have ability to get a hold of you and that you remain within 10 or 15 minutes of the courthouse so that we can get you here, okay? All right, we'll be in recess.